makes it 1056 and 1057.
And what's that? I'm not sure I have it with me.
This is the question of establishing the specific intent by looking at a series of inferences from policies, from acts, from the scale. And if I could also, that is on the question of deducing an inference, and this actually responds to the point that was raised by the defense about how you raise specific intent. You have to show positive action. But these positive actions...
I'm going to interrupt you because we're discussing, and I'd like to hear, is this not referring to individual responsibility and not state responsibility, this case law? I think it is, but you know better, probably know better than I do.
Well, it's talking about the offender's specific intent. So if on the one hand you find that the state is the offender, then how do you establish, this is on the question of how do you establish specific intent. And of course it's very difficult to find specific intent because, even, as has been said, even the mind of the devil is not triable. So how do you then deduce what the intent is, other than by looking at the acts, the scale of acts and so on. And those paragraphs 5 to 3 at page 1056 and 5 to 4 lay out the whole range in which you can therefore deduce the mind. It says, in fact, on the issue of determining the offender's specific intent, the Chamber considers that intent is a mental factor which is difficult, even impossible, to determine. This is why, in the absence of a confession, his intent can be inferred from a certain number of presumptions of fact. And it goes on to talk about inference, and although it talks about the specific, but it also must therefore be attributed to the whole.
But the state doesn't have a brain.
Yes. Therefore, then
we rule that a state can be liable, and this is the position of the chamber, of the tribunal. But how can it be incurred?
Yes, it can be incurred. To discover that, in fact, it was in my submission where we talked about proof is usually through speeches, public declarations, meetings, statements, the context of the crime, its massive scale, elements of its perpetration that suggest a particular animus towards the group. And then also we quoted the Yusu's case. He talked about factors such as culpable acts systematically directed against that same group, whether these acts were committed by the same offenders or by others, and scale of atrocities, and region, acts of deliberately, and so on. So obviously this is talking about the complexity of a state, because when you talk about this kind of, in other words, if you can, like Kaslak, for example, or Sabra Shatila, you can come within the first part of the quote that you made with regard to the state being attributed with powers, and then talk about establishing specific intent, then this is how you derive that specific intent. And also the repetition. In Simba's case, he talked about the repetition of destructive and discriminatory acts. And the repetition is the one that is overplayed. Of course, if you show a plan, a direct plan and policy, then that's the end of the matter. That's most useful. But in fact, if we look at our submission, they said the plan, the declaration of a plan or policy is not the Milosevic, the Karadzic and Mladic case, which was a case on genocide, talked about intent inferred from a number of facts such as general political doctrine, repetition of, and so on.
Actually, those are only pleadings because they haven't been found guilty yet. For Karadzic and Mladic, they're still on trial.
That's right.
But anyway, that's
right. I stand corrected here.
Well, no, it's just a fact. You said it actually in your document. You did say it was pleadings and not judgment.
I did say that, yes. Therefore, to sum up that particular in answer is that if you look at, we are entitled to infer even without the showing of an official plan. And then if you look at these acts and infer logically, then the inference is very clear that these were acts perpetrated in pursuance of a policy that started as long ago as 1947. So that is our contention.
Your Honors, if I may please support. In regards to the first question of how to, the appropriate manner in which to deduce whether or not state responsibility has in fact been triggered, I would invite the bench to read paragraph 413 of the genocide case, which shows the actual application of the rules. It demonstrates the various levels by which the International Court of Justice deduced that the Bosnia and Herzegovina were not liable for the acts themselves. In particular, Article 3A of the Genocide Convention, in regards to Article 3A of the Genocide Convention, the activities were not committed by actors or organs of the respondent. The massacres were not committed under the instructions or direction of the respondent. No effective control and no evidence of specific intent, which would have had to be present in order for the state to be held responsible on this basis. Additionally, in regards to the appropriate test to be applied in regards to ethnic cleansing, I would invite the bench to refer to paragraphs 190, my apologies, 189 through 192, where the International Court of Justice deliberates upon this matter.
Have we reached a conclusion as to the Kuwaiti embassy?
Yes, I've been informed that according to Bayan, there were several operational areas from which Israel IDF forces operated, and the Kuwaiti embassy was one of those.
I sort of thought that's what it was, but I wasn't sure. Thank you very much.
Okay, Your Honor. So very quickly, I'm only going to respond in very short responses. I think, as far as the legal points that were made, I think that's with regard to the state of Israel, it's quite clear that we are only going on the question of genocide. As regards positive actions, how these can be proved how specific intent can be proved, I've already referred to Bundle 2B 1056, and as well complicity, that's at 1059, Bundle 2B. So I shall not delve further on that matter. As far as on this point, although on the defense submission by Mr. Jason, Pansri will respond to that, but just to respond to that immediate point about command and superior responsibility, I would say that both are being raised, because one is his location in the hierarchy of events, that's one, to the command, but it's also individual, because if you recall yesterday, when we talked about the fact that Yaron did not disclose as he should have to his superiors, and that action by itself would suggest that it is not just the command responsibility we are talking about, also individual responsibility.
Were the militia his subordinates, is the question. Were the militia his subordinates? That's my preoccupation, and that's where I think the defense raised the issue. Were they just people following orders or being incited, or were they subordinates? Were they integrated into the Israeli command? That's the kind of thing I'm concerned about.
But yes, but if you look at the Kahan Commission, we appreciate that point, but if you look at the Kahan Commission report, it will show that there was complete coordination and that the Phalanges forces were acting at the direction and behest of the Amos Yaron. I think they have made it very clear that prior to and during the event, they were acting at the direction, behest, and control of the defendant.
So, is the prosecution invoking personal liability of Yaron because he ordered and participated and cajoled and incited and etc., or are you saying he is responsible because he's a commander and there's a case of Yamashita in
Yes.
the States, U.S. law,
Yeah.
which I haven't read completely. And there's also cases in international criminal law. We call it 6-3 responsibility or 7-3 responsibility of the commander. And even though he didn't commit it, which are you invoking?
Well, we are, of course, at the first level, we are invoking the command responsibility, and we look at the whole series of events. But we recognize that there could be gaps in establishing command responsibility vis-a-vis the phalangists who actually perpetrated the actual acts itself. And therefore, we are also looking at the fact that he, with knowledge and with an ability to, with his authority to direct and control, and failure to act after being informed, also incurred individual responsibility. We are having a fallback position, in other words. So our first line is command.
Thank you.
Yeah.
I'm not sure which is stronger. I think the second is stronger.
Yeah.
I'm not sure what to think of it.
Yeah. Now, and then on the question of ethnic cleansing, yes, of course, we agree General Assembly resolution is soft law, it's not law. But we cited the authority to suggest how it provides a guide, persuasive guide to determining what the attitude of the world community was. So that basically is my response to the legal points that were raised. The point with regard to ethnic cleansing is that we agree the judgment did not find ethnic cleansing equals genocide, but they raised the fact that ethnic cleansing can amount to genocide in certain circumstances, and that was our point. As far as the submission of defense is concerned, I'll run through some of the points very quickly. Now, the point about the population, I mean, it's not a numbers game to see how many were killed and divide and multiply and subtract. This is an absurd proposition, if I could say so with respect. If that is the case, then I think there was no Holocaust, because today the Jewish population is far higher than it was in Germany. So I only have to state this to know how ridiculous it is to suggest that because today the Palestinians by the census of 2010 and 2050 are more, therefore no genocide. It's not a numbers game. It's not about big numbers or small numbers. Even if you kill one, and I've cited authority, with intent to proceed to kill others, that suffices. That's not a big number. So that is the point. As far as Yaron's case is concerned, I will leave it to Tan Aziz to deal with it. I'll just quickly run through the other points they suggested. They talked about Palestinian National Council, Hamas, and what just charter and stuff is that they don't recognize the existence of Israel. I think it's common knowledge that now they're engaged in a very active peace process and trying to establish a two-state nation. Everybody knows that. I think the defense should also try to keep up the current affairs that will demolish this point. As far as all this whole explanation by Dershowitz is concerned, I think you know who Dershowitz is. He's an unashamed apologist for the supremacy of Israel, come what may. And don't take my word for it. I just have got here a report which says Alan Dershowitz Zionist views, his views, not him as a person, unwelcome in Norway. And I'll just read this, I've got copies here. In a recent article, notorious Zionist Alan Dershowitz reveals the scale of rejection he faced on his recent visit to Norway. Ahead of his visit to the country, Dershowitz lectures were offered at the three leading Norwegian universities. These universities, who on earlier occasions had been happy to host Harvard scholar Stephen Waugh and Israeli historian Ilan Pape, who was our witness, clearly said no to Dershowitz. So they explain why, because of the fact that he establishes this kind of, because of his reputation as being a thoroughly unashamed, biased proponent of the Jewish state. Come but me. I'll just leave that and give copies So that's so much for Dershowitz's credibility, and therefore I suggest we reject that. Now, as far as the Samoni Zaitun incident is concerned, you're talking about the military advocate general. I mean, you're talking about people who are part of that military organization, and therefore I would suggest, with respect, and I read out the Jerusalem Post itself, which is a post that is from Israel itself, which said that this is a terrible incident that requires investigation, and for the MAG to suggest that no action should be taken was something that was entirely unacceptable. And I also submitted articles from Guardian and Al Jazeera to much the same effect. Now, and also the Kaslet operation must be put in its context. We are looking at genocide as a whole. Samoni incident must be put in the context of Kaslet as a whole. It was not just Samoni. As far as Goldstone report is concerned, the Israeli Ministry of Foreign Affairs issued a statement. It's very interesting. They issued a statement about Richard Goldstone, how he's retracted. But that's not the point. It's not the point. It's what the Commission said and heard and decided upon the evidence that was presented to them. Not an afterthought by him, because we don't know why that afterthought came about. We don't know the circumstances as to why. We're looking at the report itself. Apartheid state, all I got to do is refer you to, there's a book by Jimmy Carter, who actually went there, and it's called, I'll give the name of the book in a while. It's published by Simon & Schuster of the United States of America, and the name of the book is Palestine, Peace, Not Apartheid, published in 2006 by the publisher Simon & Schuster, who makes out a very clear case of the fact that there is apartheid. But our case goes beyond apartheid, of course. We are talking about genocide, so I don't want to detain ourselves here. With regard to water and Olympic-sized swimming pool, I think this misses the whole point. We are looking at ICRC report. We are looking at UN reports that talked about the dire situation in Gaza and West Bank in relation to water. So I think one Olympic-sized swimming pool cannot demolish the detailed findings by these bodies, and I've already referred in my submission to these independent bodies that have talked about the water. I think the United Nations, the water is, this is a report by the UN report Center on Housing Rights and Evictions, which I've cited, and a report of the Special Rapporteur on the Situation of Human Rights in the Palestinian Territories. And they talk about the effect of water upon the Israeli population as a whole. So I don't think this one Olympic swimming pool is going to solve that problem. Now, as far as the wall is concerned, I think you have 100, and you can call it what you want. We have no objections to you, labeling it any which way. But it clearly is in occupied territory. It's at least 190 kilometers long. Whatever it is, you are presenting a position now. It was suggested that the Israeli Supreme Court has made some comments about how, it is security, and they've criticized the ICJ, but I would suggest we stick to international jurisprudence on issues which involve international law, and the ICJ has very clearly repudiated the question of security, the question of necessity. They considered these questions. There were written submissions by Israel on that point, as well as oral submissions, and they have made a very clear pronouncement that it is not justifiable either by necessity or security reasons. So I would refer that to these two Supreme Court decisions. Now, as far as suicide bombers is concerned, you see, we here are talking about genocide, and we have given specific instances of genocide. What are they suggesting? That we can commit genocide because we have a reason to commit genocide? If that's the case, then we must exonerate Nazi Germany. Because Nazi Germany also had a reason. They said they were also subject to this, that, and the other. So that is not the point. The point now is, was this act genocide within the meaning of the Genocide Convention? And that is the key point. And we have established with respect this fact. Now, as far as border checkpoints are concerned, it was suggested that Malaysia also has, these are immigration controls. But we saw the pictures. I think they speak, the video speaks 1,000 words, if not more. We are talking about 730 checkpoints in a small occupied territory like this, and what it's subject to. So I have nothing more to say. I mean, I'm not blaming those young boys who are trying to give a good image as to, please don't take pictures of us, put us in a bad light, and they're not cruel people as such. But we are talking about the concept of checkpoints, which hinders movement at every stage and its impact upon conditions of life. That is what it's about. Not about whether the soldier was dealing with pirate customer. This is not about, buying and selling of stuff. This is something far more serious than that. Photographs, it is suggested shattered lens photographs are, they also presented photographs, so I'm not going to say too much because I don't want to disqualify their photographs by their own submission, that therefore you reject them because shattered lens says, you can put a gloss on photograph. Photographs sometimes speak the truth. I'm reminded of, I think it was the French producer, Melieu, I can't remember his name, who, presented a sour series on India, and then the Indian government was very angry. They condemned him for that. And he says, all I'm doing is depicting the truth through these films. So look after the source material from where I'm getting this, rather than condemn a depiction of it. And so photographs are an attempt to depict, videos are an attempt to depict what we sometimes can't get to see. I have tried to go to West Bank, but the Israeli government, like their control, rejected the application by some of us from the prosecution to go there. Now, as far as life in Gaza, we're not saying that life has come to a standstill, but we are talking, and I refer you to the reports by the UNWRA, by the United Nations commissions to say that it is not going to become habitable at all. I mean, that is the point. All that is going to disappear if this goes on. All those pictures that were shown in one section is going to disappear. It's not going to be habitable at all. And this is not us saying it. It's not the defense trying to refute something that is being predicted by a commission of experts. There are two reports on that.